Arman, thank you again for joining us for another discussion on the FTC trends and antitrust. I think this is the third year in a row that you and I have had conversations on this and have collaborated on other writings. So I'm really looking forward to the insights you're going to bring today.
It's a pleasure to be here, and thanks for having me.
So maybe before we jump in, because I don't know if all the audience is up to speed on how the FTC's really evolved since Lena Khan took over in 2021, maybe could you just start with a short overview or summary on how it's really evolved since she took over?
Yeah, happy to do that. So before the current leadership at the FTC, we had during the last administration a leadership under Joe Simons, who's a celebrated and well-known antitrust practitioner. He's practiced at major law firms as well as at a number of positions within the FTC. And under his leadership, there was quite a bit of scrutiny. I don't think it was a laissez-faire kind of FTC to say the least. Nevertheless, with the change in the administration after Joe Simon stepped down and the Biden administration came in, I think it's fair to say that we have a much more enforcement-minded administration, both at the Department of Justice Antitrust Division, which has concurrent jurisdiction in merger enforcement, but also at the FTC. And for those who don't know how the FTC works, it's a New Deal era independent agency in the sense that there's a commission. There are 5 commissioners. 3 of them, no more than 3 of them are supposed to be from the same party. So typically, if the administration is Republican, then you get 3 Republican commissioners and 2 Democrats. And then it flips when the administration changes. It doesn't have to always follow the administration, but it typically does as convention. Right now, it's a commission with only 3 commissioners. The 2 Republican seats are vacant.
Yeah, certainly a lot more sort of, when Lena Khan took over, the FTC had some really headline-grabbing deals it was pursuing. So you had Microsoft Activision, you had Meta and Within, you even had the Amgen Horizon deal. However, it seemed like they weren't getting many wins. Can you maybe comment on, what was happening in the early days and maybe why was the FTC not so successful in finding these enforcements that they're pursuing?
Well, it's really hard to challenge a merger to begin with, and that's particularly true if you're going to pursue new theories or application of existing theories to more challenging facts. And the Meta Within transaction is probably a pretty it's a telltale story in the sense that this is obviously a very large buyer, Meta. Buying a very small company Within, compared to Meta, a very small company, in a space where Meta could have gone into on its own as a potential competitor. And it turns out the FTC challenged the transaction under the theory that, well, Meta could have done this on its own. Why is it buying a company like this? So this is a potential competitor buying a small company. And really, the underlying tone is that Meta should have entered the space itself. And Within is a virtual reality workout app. So it's not like from a public policy perspective, a hot area like life sciences or whatever. I don't mean to diminish the business models. It sounds like a great app. It's just that from a public policy perspective, the interesting part for the FTC was this antitrust theory about how potential competition could be diminished as a result of an acquisition. And they couldn't convince a federal judge that that was the case. So this was from a theoretical perspective, a challenging theory. And it plays out in the current administration, both at the FTC and the Department of Justice. We see more novel theories of harm to competition as the basis to investigate and or challenge transactions. One could argue that Microsoft Activision wasn't so novel, although it is a vertical transaction. And one could argue that, well, typically in past administrations, vertical transactions come with the benefit of there's something pro-competitive about combining vertically related assets. And here they didn't get that benefit of the doubt for sure. But again, the parties prevailed. Um, and um, and similarly with Amgen Horizon, there was a novel theory that somehow buying an existing dominant product, which FTC alleged Horizon already had, would create more market power in the hands of the buyer. That's a new concept in the antitrust circles. It's not a new concept. It's a new it's been argued before in investigations, but we never saw it actually being adopted by an agency to the point of challenging a transaction. So the moral of the story is they tried going after some more ambitious novel theories, and in some of those cases, they just didn't prevail in convincing a court, which, of course, on this side of the Atlantic, compared to Brussels, for an agency to block a transaction, they need to convince the federal judge to do that.
Yeah. Yeah, I thought the Amgen Horizon one was really interesting. From an outside in, I don't know the details, but they seem to be accusing Amgen of something that's actually illegal to do, which is to be bundling products in their negotiations with payers, which is they'd never been found guilty in any of their court of law of doing, and yet they were suggesting that that would occur across the thyroid disease, the different thyroid disease products that they had, as part of the combined portfolios. So it seemed to be a losing cause from the outside in from the beginning. I don't know if they didn't understand that that was an illegal behavior, that they were sort of in a subtext way accusing Amgen of doing, uh, but it was certainly there. Um, you know, 2023 did seem like a sea shift though for the FTC. They seem like they had some wins. There's Illumina Grail. I think you could consider the Sanofi Maze deal a deterrent. What do you think the FTC started getting right, at least from their perspective, in order to get these victories?
Look, I don't think they're doing anything differently in 2023 or now 2024 than they have been doing in the past. Um, one could argue that Illumina Grail was well, that was actually brought by the FTC under Joe Simon's leadership. They investigated that transaction, and they brought the initial challenge. And the current administration at the current leadership at the FTC continued that investigation and challenge. So no surprises there. And they prevailed legally. So I guess congratulations to the legal team, the litigators at the FTC for securing a win. But I think the Sanofi Maze transaction is interesting in that we see another more aggressive theory of enforcement play out, except the parties abandoned the transaction. I mean, one could easily see how that challenge could have played out differently in a courtroom, with evidence coming from third parties, whether it's some of the other competitors with um, almost commercial assets like Amicus, and other pipeline assets that were in the works that looked very similar from a technology perspective to Maze's technology, and even more innovative technologies that were about to go into clinic and may very well go into the clinic very soon. So with that dynamic, I don't know how the FTC would have done in front of a federal judge. I think the parties had a lot to play there from a litigation perspective. But these things are expensive, and for a small company, especially, very risky to go through a prolonged investigation and then prolonged litigation, especially if you need funding to get through all of this.
Here you had a phase one asset, or asset just finished phase one. They needed the funding to go phase two. There were several phase two assets by other big pharma companies, that some of them which are gene therapies that have the potential for curing at least portions of the Pompe disease population, which, for the audience who's not familiar, Pompe disease is about 10,000 patients globally. So very rare disease. And yet they were assuming that Sanofi would have a monopoly with the Maze deal. It just seemed, the counter argument that, during your session I made to Rao was, isn't this just more the case, given the Maze therapy is a symptomatic drug? more of Sanofi just trying to maintain a foothold in Pompe disease in the future because they don't have the gene therapies that Roche and other players have that would potentially be a better product to their current existing portfolio. It seems very strange.
Yeah, no, you're making very good points. And look, I of course I don't know the details. I did not represent Maze or Sanofi in that transaction. I'm familiar with the disease state and some of the players in it, and some of the arguments you just put forward could have been winning arguments, um, especially before a judge. I'm surprised they didn't necessarily play out that well with the FTC staff. And then we ended up seeing a complaint challenging the transaction, and none of this was necessarily given any credit in the complaint that there might be a tidal wave hitting this disease state, hopefully for the patients with gene therapies, and that Sanofi was not a player necessarily in that technology. So sure, those were earlier stage asset, but were they a lot earlier stage than Maze's asset, which is
No,
a
they're actually
debatable
later
proposition,
stage,
right?
right? They're
Yeah.
technically later stages. That's the thing that
Yes.
was.
So all of this is it's unfortunate for the parties. I mean, I think Maze, the technology would have probably benefited from the funding and the support from a big pharma. Not only the know-how and the financial support, but being being the main player. I mean, FTC challenged Sanofi as being the monopolist, and let's assume that's true.
Mm.
That to me means that they have the ability to take this product all the way and bring it to market, and then provide one more solution to these patients, while still probably being disciplined by a whole bunch of other technologies in the wing. So whether they have the ability to exercise said monopoly power it was really questionable. But again, I haven't seen the details of the evidence. FTC was not comfortable with this particular buyer, right? Um, and I think it's fair to say that in the current um, leadership of the FTC, we see a lot more comparisons between the proposed transaction and what that would look like in the future versus what would happen if there's another transaction, and who that might be with, what are those alternatives. So comparing the transaction to another future world involving other potential buyers, other potential collaborators, as compared to doing the analysis based on what is going on today and what's going to happen tomorrow if this deal gets done. So those are slightly different. I know it's a nuance, but it's an important nuance in merger investigation. Are we comparing the status quo to the proposed transaction, or are we comparing the proposed transaction to a different transaction? And unfortunately, that seems to be one of the other dimensions that we end up having to respond to during investigations, especially in the life sciences, because it's almost axiomatic that some of the small companies that do a lot of the innovation will ultimately have to do a deal to bring the product to market and patients.
Last I checked, Maze still doesn't have a deal. You know, the deal was abandoned in December after the FTC pursued it, and so here is a small biotech company without funding. You know, I think the FTC may be hoping like VC or another pharma company that's not in Pompe disease would pursue it, but that may not be the case, and so then you have patients with one less treatment option potentially.
Yeah, no, very good point. And look, I don't want to always talk about the FTC as one monolithic thing. There are a lot of fantastic people who do really amazing work at the FTC, and as those of us know full well who deal with other agencies across the globe, all else equal, of course, the mergers one within the FTC knows the industry far better than any other regulator. And it's always a pleasure to deal with people who know the industry better than other regulators. Having said that, it's a challenge to explain some of these concepts. It's not always obvious to folks at the FTC that if you don't do this deal, it might be over. And I'm not suggesting that that's necessarily the result in this particular transaction, but in many cases it's really hard to move and do another round of financing, et cetera, if you were not able to do an exit transaction for an asset, and that has consequences.
Yeah.
So it's a key issue, and we deal with it, unfortunately, on a daily basis. In some transactions, we're successful in convincing the staff and getting them to understand these dynamics. And as we all know, like most deals get done. So some deals don't get done, but most deals get done. So that's a little bit of silver lining.
One thing that you brought up during the Goodwin KPMG event that I think would be good for this audience to hear was the role that contractual provisions can play in terms of ensuring that, for example, in the Santa Fe Maze deal, did they have contract provisions that would ensure the asset would get funding, right? And prevent any kind of acquire and kill type scenario that FTC I know is concerned about. What are your thoughts on the FTC's point of view on that? Is that something that is, a way to ensure an allowable deal, or are they against that?
Yeah, so it's a tough question for the if you ask the leadership at the FTC, they would need to, of course, acknowledge that if a deal has, in their view, anti-competitive effects or potential anti-competitive effects, um, they cannot rely on a contractual provision that between the parties, for example, to continue to develop the asset and or provide the product at a certain price or under certain conditions. If you take the Amgen Horizon deal, for example, the concern was that Amgen, as the new owner of the quote monopoly products that Horizon had, would be able to bundle some rebates and things like that to maintain the monopoly position of those products more successfully than Horizon could have done on its own. Now, those market access practices, the parties said we wouldn't do those, and FTC was not comfortable with that promise. And I understand the concern. FTC is not in a position to continue to regulate on a daily basis what companies do after a transaction. Now, having said that, between two parties, especially in collaboration type deals, right, where the two parties are going to stay independent, but there's a deal over a particular asset. If there are provisions in the contract that say, well, okay, we're going to do a collaboration over asset A, and Big Pharma is going to fund it, it's going to do this, it's going to do that. Big Pharma is committing to do a phase 2 trial. Big Pharma is committing to do whatever the development necessary outside of the US and so on, which a lot of our collaboration agreements do have, right? And there are milestones built in to reflect all of that work. If those incentives are there, now the FTC staff and leadership will say, well, those are not necessarily going to undo for us or obviate the anti-competitive effect of a transaction. But the reality remains they have to take it into account. Because if the incentives are built into the contract for a private enforcer to be able to say, no, you need to continue developing my asset, especially if it comes with reversion rights, right? If you don't develop it, I get it back. So those things in practice make a big difference. But if you ask the leadership, they can't really acknowledge that because it would sound like they would be willing to take Amgen Horizon like or Microsoft Activision like commitments to clear deals. But in practice, this is something we pay a lot of attention to.
So it's interesting that this that should, in a way, allow certain deals to path forward. And I'm assuming the Sanofi Maze deal probably had something like that. And we don't know, but assuming it did. Any thoughts on why the FTC wouldn't allow that deal to play out and then at a later date? So at least the funding gets through to the drug for the patients to go through the clinical trials. And then if 4 years from now or whatever it is, Sanofi does have a monopoly and they still own the Maze asset and are commercializing it, why wouldn't they just do the decision to break them up then as opposed to doing it now?
I mean, if they truly believe that this is a monopolist buying one of its very close competitors, any contractual provision that says, okay, well, Sanofi has a commitment to develop the asset up to a certain degree at least, uh, is not going to necessarily be a good practicable way for the FTC to enforce the antitrust laws. In theory, of course, they could play it out, wait for what happens, and only if Sanofi, after developing the asset, shelves it or kills it or somehow positions the two assets, its existing assets and the Maze asset in a way where the two are not competing with one another, and then step in and say, well, okay, well, we let you have your day in court now. Like we were still not comfortable with this outcome, so now the outcome is unlawful. That would require them to challenge the original transaction, which is now 5 years, 7 years in the past, because otherwise you're looking at perfectly lawful conduct. But they could, in theory, challenge the consummated deal that happened in 2023 and bring that challenge in 2030. But as a practical matter, for a law enforcement agency to get into that business is really, really hard to do. It would need a lot more resources, and they would need to be more like a regulator in the traditional sense of the word, as opposed to a law enforcement agency, which is what they really are.
The other element that I think is important here is, it does feel like the FTC has gotten more focused in pharma on early stage deals. So deals of, phase one assets. Is that your impression? Is the FTC looking deeper in the pipeline?
Look, for sure, there is no doubt about it. They say that expressly now. They're not content with just looking at commercial and or about to be commercial assets. They don't limit themselves to assets with proof of concept. So like after 1B to whatever, they're going deeper and deeper into the pipeline. And with mixed effects, right? I mean, it's good that they're trying to understand the industry more. That's fantastic. At the same time, some of the early stage assets come with the obvious, like really wide um, um, risk bars, right? And what I fear sometimes is that somehow the transaction comes with the presumption, or the FTC approaches the transaction with the presumption that the very fact of a transaction suggests that the asset is somewhat de-risked compared to similarly positioned assets. It's harder to convince the staff sometimes that, well, okay, that asset is also in a similar state of development, so we need to take all of those as potential competitors. If ours is a concern, then, well, to the buyer, all of these other assets should be a concern to the buyer too. So where is this notion of they're buying to kill the asset coming from? Like, are they going to do it to all 9 other IND stage assets? So there's a little bit of that consternation, certainly on the ground for us, going through the science and the details of other assets about which we know a lot less, right? If we're representing the parties, we know our asset, we know what has been de-risked and what hasn't been de-risked. And it's a lot harder to marshal the evidence with respect to similar assets. So that's a little bit of a consternation.
Excellent. Well, this has been a really great session. Any final thoughts you want to leave with the audience?
Look, deals are still getting done. I think being ready for the FTC is the best strategy. It used to be that we would get ready once we get a deal like signed and whatever, and then try to understand some of the scientific nuances. Now, being ready early really makes a difference, and educating the staff who are trying to do the right thing. If you can go in and explain it to them as soon as they have questions, it goes a long way.
Excellent. Well, Arman, thank you again. This was a really great session. Really appreciate all the insights you brought today.
Hey, thanks for having me. Always a pleasure.